Welcome back, everyone. Craig here. So you've probably heard the term get it in writing. And I think in many ways that whole idea that if it's not in writing, it's not enforceable is a bit of a wives' tale. Um, there are generally ways around it. It's better, if possible, to have things in writing, but it's not always essential. But I actually had a case today. I had a hearing, I had a motion I was opposing on one of my cases that I lost, and it was a tough case. And I can't really give too much of the details of it other than I represented a woman who uh had a kind of a bad problem with a nationwide bank at one of its local branches regarding the application for a loan and some information they gave her that wasn't very good. Um, and so the case kind of came down to it's a bigger bank, and they have all these forms and they have all these disclaimers and stuff on them, all the boilerplate stuff that no one ever reads, but we all just kind of sign them and stuff. And so we had sort of that, and the bank was kind of like pointing to all that stuff. On our side, we had these phone conversations, numerous phone conversations between my client and the bank agent, and but there wasn't any emails or text messages that we could find. It was just all oral. And the stuff that my client did in response to what she was told makes it pretty clear, at least it does to me, that what she said happened. And I think for the most part, I don't know that they were disputing that much that they said it, but they rested on this concept called the Statute of Frauds. And it's something that I don't see very often, but it comes up from time to time. It was something that we learned in law school many, many years ago. And the statute of frauds, and I can't even tell you every element of it, but essentially it says certain types of contracts. You can have an oral contract, but certain types of contracts need to be in writing before the law will uphold them. And examples are like contracts for real estate. I think contracts that take, is it more than a year? There may be one over a certain number of dollars, but certain types of contracts or agreements, maybe we'll call them agreements, in order to be enforceable, have to be in writing. And if they're not, a handshake isn't going to be enforceable um, if it's not in writing in certain circumstances. So the statute of frauds basically says, look, there are certain types of things that if you're going to claim that someone committed to something, we want to see it in writing. Otherwise, we're not going to recognize those because it can encourage people to be um, deceitful, can make it up, and it can just be difficult to figure out the details, the terms, whatever. And so uh, that was the argument in this case, and it was based on a banking statute that I was arguing had been violated. And I thought we could get around it. I still think our position was pretty good, but the judge disagreed, and maybe the judge got it right. I'm not here to say that she got it wrong, but reasonable minds could differ about it. But it was a case I took on because I felt I thought there was kind of an unjust thing that happened to this poor person. Thought she acted in good faith and was really, kind of mistreated by the big bank who kind of relied on their corporate drafted forms and all that. So anyway, I we took we did our best to try and get something for her. The judge disagreed with me, felt that the law was on the bank side, and so we lost that. Um, but it's just a good reminder. It is, and it could be a text message in most states. check your state, check your jurisdiction. But, if you can get it in a text message, that's better than an oral conversation. If you can get it in an email, that's probably better than text message. And if you can get it in a notarized document, that's probably even better. But that's kind of what the statute of frauds means, and sometimes it does come back to bite people. Um, but wanted to, just because I had that happen today. I know that people sometimes don't know what that means, so you don't have to have things in writing. Sometimes you have to under the law, otherwise the courts won't uphold it. But even if you don't have to have it in writing, it's almost always better to have something in writing, memorialized. I don't know what that means in the world of, you know, uh, video, audio, Zoom. You do have the ability to record video and stuff so much easier than we used to. So maybe that's, if there's a video recording of it, that may help. But then you got to be careful, because not in every some states you can't record a conversation with someone out without their permission. So it's important to get their permission, get their consent to recording a conversation if you're not sure about that. But that's the statute of frauds, and it's unfortunate. I thought we had the better argument. I thought we had a kind of a compelling case here, but maybe I was wrong. So just kind of as a warning to others out there, if you have questions about that or comments, feel free to leave a message. If you're looking for an attorney, or it's more of a legal related question, don't leave a comment. Send me an email. Then it's confidential and I can respond to it. So thanks for listening. Till next time, everyone. Have a good one.